All right, Bama Law. I'm back. How are y'all doing? Thanks for joining me. This is it's like my third attempt to do this. This will be the last part of the criminal procedure for a jury trial, at least for in Alabama. Uh, this is This is extremely broad, so don't take this as a. Um, I'm hoping it'll actually. I can't for some reason share a PDF. I don't know why. I don't know. So I'm hoping this turns out. God, I hope it does. Because I really don't want to do it a fourth time. All right. So let's see if I can get this to work. No, already. Huh? I think it's working. Yeah, we'll see. Hopefully it is. All right. Back to circuit court. Charges and indictment by information and complaint rules 13.1 to 13.5. Um, Again, you'll be read the charges, the indictment. You can waive it, make everything go quicker, um, and you'll get a copy of the complaint, the official one, where it says you've done something against the peace and dignity of the state of Alabama. That's all right. That's what you do. From here, you have two different prongs that kind of come up first. One, you may get a judge. They may not do it, but they usually do it like a scheduling order, similar to civil court, that just sets the purposes and scope, sets boundaries, deadlines for discovery, pretrial motions, keep the docket smooth, tailor or clean and trim, and keep it on track. Uh, at this time, you better make sure that you got the correct jurisdiction and venue, or that that they're trying you in the correct court. Um, you know, if you're trying to, think, well, the cops are always against me. They're always against me, man. I can't because I had client. You always get those clients. Oh, the cops are against me. Oh man, their whole system's against me. I want a trial moved. Well, okay, I want a pony. I mean, you're not going to get a trial moved for that reason. It's a real high standard to try to move venue. Like the jurisdiction is the entire state. So if you commit I don't know, let's say a murder in Jefferson County, Alabama, which is Birmingham, uh, they would, and it's in Birmingham. There's two two tracks. There's the Bessemer track, and then there's Birmingham. So you wouldn't be tried in the Bessemer one if you're charged to have done something in the Birmingham um, track. And in order to actually get that moved, you have to show a high degree of bias in the community, or that you can't get a fair trial. I mean, it's very rare, very rare. Let's see if this thing's still working. Looks like it might be. I think it's working. Imagine that. So if we've got venues correct and jurisdictions correct, this is where people start to they'll start usually a few months in. Because by the time you get to indictment, dude, you may be a year into your from arrest. You might be 1 year in. And so it's usually where people start getting antsy and they start wanting to, man, I want speedy trial. I got to write a speedy trial, man. It's like, you did. You did. We discussed this in district court. We needed to assert it there. If you don't do that in Alabama in district court, it's waived. You're done. So you're on the roller coaster. You're going to be forever. Um, I mean, I've had cases go 3 or 4 years before we even got to trial. It's not normal, but it's not out of the realm of. It just depends on the docket and how long you delay based upon getting evidence. Setting another. Because every time you bump a hearing out for pretrial, it's at least 90 days, almost usually, unless you start pushing to get it. Now, let's go, we got to go. So this is usually where people start, and they're not happy when they find out they done screwed up and um, they didn't choose to assert their speedy trial right, because the attorney should have told you that in district court. Sometimes it doesn't get done. You know, People are human. They make mistakes, but the attorneys, I don't want to say they're not supposed, they can't, but really they can't. I mean, this is somebody's life you're messing with, so you better have given all the info to the defendant. Your client, you owe them the utmost duty to not only be a zealous advocate, but to make sure that you're actually representing their interest and not screwing them over. Let's see if I can get this to. Okay. From here, we go to pretrial conferences. The purposes of them. Again, this is all a very high overhead shot. I'm going to try not to get bogged down in it. I'm just trying to give you an idea of the procedure of how this moves. Um, you start getting pretrial conferences. You start just working things out with the court and prosecutors, finding out if you have suppression issues or discovery issues, or uh, maybe start do things like subpoenas to try to get um, information from, maybe, I don't know, credit card company or phone company, etc. Because you have to get a lot of states allow the lawyer to do a subpoena execution. Alabama does not. You got to get the trial court involved. They have to issue it. It's a pain in the ass. It takes forever, especially if you have to do more than one. It just sucks. But it is the system. It is what it is. You can't. I think it ought to get changed, but it's just not something people care about. After your first pretrial conference, and you may even get one at it, it's very possible you'll start getting your offers to plead guilty. Um, if unless you're a first time offender, um, as I've got it right here, unless you're a first time offender, you are probably going to prison at this point. Because chances are you're not on a charge that, I mean, you could be on a charge, even with a prior felony conviction, as long as you're not what's called HOFA, or Habitual Felony Offender Act, as long as you're not getting tagged for, prior felonies. Um, Even if you got one, if they don't invoke it, then you might have a felony. You might be a felon, but you might also get what a first offender would do in a case like for methamphetamine. We'll go back to that example. You might get an offer. Um, you might even get lucky enough to get drug court, where you can go into a drug court or treatment program run by the court. At this point, you've probably lost that option. That would have came before the indictment, and you would go into drug court, which is most of the time circuit courts run it. But the drug court program works. It can. It's all, whether or not you want it to work for you. From here, if you're not getting that sweet deal, um, like I said, you're probably going to prison. If your lawyer hasn't gotten their shit together, and for you, you're probably going to get your boots smoked. Um, from here out, the offers, it depends. They can get worse. Sometimes if you take it to the limit, uh, you can you can sneak out a good offer. You're probably going to have a prison sentence in it, but when you start staring there looking at the statutory, um, punishment, and you're like, oh man, I could do a year and a day up to 10, and they come back at this point, you might have been able to get, I don't know, like a 24-month split one or something, if you're real lucky, and serve a year. Actually, less than that with all the good time. But this is the last time you're going to get like, okay, well, we'll do a 5 split 2, or and serve your 2, and the rest be on probation or something like that instead of the 10-year sentence. We go to trial, we're asking for the full 10. The jury doesn't have to give them that, I mean, the judge doesn't have to give them that and the conviction, but that's what they're going to ask for. That's what they're going to get. Almost always. Almost always. Okay. All right. So, how can I get this to scroll in? Here we go. I'm sorry, y'all. I'm still learning this. Woohoo. Here we go. Yay. Trial by jury. Rule 18.1. Come on. Scroll over. Right to a trial by jury. Defendants in all criminal cases shall have the right to be tried by a jury in circuit court. In circuit court, not district. Remember that. It's the only time. District bench trial. That's it. That's all you get. In cases triable in the first instance in district and municipal courts, they should have the defendant. This is the little back door to get a jury trial, though, on a district court or municipal court case. They never get one. And there's just no way. There is a way to do it. This is it. The defendant shall have the right to a trial by jury uh, only on demand upon appeal to the circuit court for trial de novo. De novo means to redo it as if it was fresh, never been decided before. And you can stipulate to appeal. That's what we called it. Stipulate to appeal. You're not agreeing with it. You're just saying, hey, the facts are here. You, I hereby acknowledge that you can probably get a conviction, but I'm doing this to appeal it. And as soon as you stipulate to it, you get the conviction or whatever, that you start the procedure of sending it to the district court for an appeal from municipal court. Or if you're in district court, then you go from there to circuit court. But this is your back door. People ask a lot of times, it's like, dude, can I please get a jury trial? I'm like, no, it's a misdemeanor. There is a back door. This is it. All right. Waiver of trial by jury. In all cases, the defendant may waive his right to a trial by jury, which you're a moron to do. There are times where it's potentially okay. Like we saw with the YSL trial with Jeffrey Williams. He entered what's called an open plea. I don't think I would have done it. You literally are putting it into the judge's hands. Everything from the punishment and the length, type. I mean, whatever the statute allows, that's what you're going to look at. She could have gave him I can't remember what the max was, but she could have gave him like 30 to serve. I mean, just depends. Um, Man, that was ballsy. But his attorney obviously. I mean, even judging from when I covered it and looked at and was watching it, they had not proven their case beyond a reasonable doubt. I don't think so. That was probably the best. Um, that's the word I'm looking for. That was probably the best instance of doing an open plea. Usually, when clients have done open pleas in the past, and I'm doing something on appellate post conviction relief, um, they have they've gotten smoked, thinking, oh, well, I'll just get the prosecutor is giving me these stupid ass silly offers of 10 years, split 3 or whatever. And it's like, yeah, dude, you could serve 10 straight. I mean, well, I think the judge will give me a better, fair shot because juries are idiots. These are all things clients say. This is all they say. This is stuff they'll sit there and tell you. And so you're sitting there having to balance baby in their ass and dealing with them, and they're whining and they're complaining and they're worried. Obviously, it's normal, but you know, occasionally you'll get a guy that wants to do an open plea. Usually, it's a convict, somebody who's been institutionalized. Maybe they've done, I don't know, 10, 15 years in the past. They're like, whatever, dude. The judge knows me or whatever, and knows that I know the judge is gonna probably give me the minimum. I don't have they know it all. Convicts are great. They're fantastic. They live and die by rules. um, as long as you do that and you're honest with them and you try to just get them a good deal, um, they're going to take it and work they work the system as much as the system works them. But they're the easiest to deal with. It's your first time offenders that are the hardest because nobody ever wants to get obviously nobody wants a felony, but there may be a case where it's like, look, man, you're screwed. There is no magic wand that's going to fix this. We go to trial, you're going to get hosed. It's just, it really depends too. Like, you may have a prosecutor that's determined that you're not going to rehab, right? That none of it's going to count. And if you do a jury trial, you're not going to be getting it. So you may want to try an open plea. Not my advice to do it, but there may be a time to do it. You can waive a trial by jury right. In all cases, the defendant may waive his right to a trial by jury with the consent of the prosecutor in court as follows. 1. When the defendant is tried in circuit court other than an appeal for a de novo, waiver of the right to trial by jury must be made by the defendant in writing or in open court on the record, and with the consent of the prosecutor in the court. Before accepting a waiver, the court shall address the defendant personally in open court and shall advise the defendant of their rights to a jury trial and ascertain whether it is knowingly, voluntarily, and intelligently made the decision. This is where they really start to lean on the attorneys to make damn sure they have any little screw up about the fact pattern or say, well, I'm pleading to this, but I didn't really do it. You done screwed up. You've got to be able to word it in a way that says basically, I don't agree with this, but the facts are what they are. It's kind of like stipulating to an appeal. There's a way to do it. Some judges don't care. They just, as soon as they hear that, they don't want an appellate decision because God forbid they get overturned on a case because, they've got, they've got a little narcissism in them and, they always want to be right. So I think that's normal in professional life, no matter whether you're a doctor or whatever. You make a decision or do something, you want to be right, but usually the judge will ixnay that one in a heartbeat the second you try to pull that. All right. When the defendant appeals, this is where we're talking to here about from municipal court or district court to get your trial by jury when you're not entitled to it. This is where we go into it. When the defendant appeals for trial de novo, he or she must demand a jury trial in writing at the time of filing notice of appeal, meaning in the district court. When you file that, when you do it and you say stipulate to appeal, they do that. You say, look, I want a jury trial on appeal. That's where you got to do it. You don't do it there, you lose it. You've waived it again. So we're back to the jury, or we're back to circuit court or district court. You can waive your speedy trial right, and you can waive trial by jury right, or you can ask for it on an appeal. From usually it's a misdemeanor case. I mean, you're not going to have a felony case, and you're just not. And for trial, district court doesn't have jurisdiction, and the municipal courts damn well don't have jurisdiction. So it's going to be a misdemeanor case. But that is the only way in Alabama to get a jury trial on a misdemeanor, right here. So you must demand a jury trial in writing at the time of filing notice of appeal. It's done that moment in court after plea. But it's not on the record. There's no record. That's the other problem I've always disliked is that there's no court reporter. I mean, you can always hire one, but they're just not done. Or in 7 days thereafter, failure of a defendant to make a timely demand for jury trial or trial by jury, so it'll be deemed waived. All right, with the consent of the court, the defendant may withdraw or set aside their waiver of a jury trial, but no withdrawal shall be permitted after the court begins taking evidence, or if the trial is commenced before a jury on a plea of not guilty, the defendant may withdraw that plea of not guilty and enter a plea of guilty in which the court shall proceed as provided in Rule 14.4, which is backwards. We're going backward into the district and circuit court where they can take pleas. We're talking about plea, not just pleas at that point. And it shall, excuse me, and it shall not be necessary that the plea or sentence be presented to, consented to, or approved by a jury, except in a capital case. Capital cases, the jury, man, that's not really true either. The jury's got to convict you. Okay. You can't go with a capital case without a jury trial. Can't do it. You just can't. In Alabama, I'm not sure how I feel about it. I don't really care for it, but what they do, Alabama can have happen to you is that you can go to trial for murder, get convicted, and the jury say life, life without or whatever, and the judge turn around and impose death. So it's I'm not sure how I feel about that, because if you've got a jury that's heard all the evidence, whatever, and they're the ones saying, "Hey, we don't think he should have be executed," then that's kind of you're putting everything in one man's hand. So what was the point of the jury trial? But that's Alabama. That's the procedure, and it's allowed. All right. You can do less than 12 juries or 12 jurors. Okay. We'll get to that here in a second. With consent of the court, defendant may withdraw or set aside any waiver of a jury trial, but no withdrawals are permitted after court takes evidence. All right. Jury of less than 12 members. Oh, come on. At the commencement of trial or at any time before return of a verdict, and with the consent of the court, the defendant may prosecutor and the prosecutor may stipulate in writing. We're back to this is prior to circuit court. This is prior to having that right in the circuit court to be able to have a trial by jury. So we're back to stipulating to appeal. Okay, that's when you got to do it. You can sit there and go, yeah, let's do six. Everybody agrees, goes forward. You're going to get a six-person jury. Yeah, the court shall not accept an agreement to trial by less than 12 jurors. I've never heard, I don't even think they can do more than 12. The grand jury will be 24 people. More than five. Nobody ever does petite juries, which I don't mind them. I really don't. Um, I've done them in other states, but you just don't see a lot in Alabama. Court shall not accept an agreement to a trial by less than 12 jurors unless the defendant being advised of the right to trial by 12 jurors personally waives the right. In any trial by jury of less than 12, the verdict must be unanimous. This section does not apply to prosecutions for capital offenses. Back to that again. Okay, so that's a death sentence case. From here, a couple of places we can go. Let me scroll over. Rule 18. All right, that was all in Rule 18. Covers trial by jury, trial waiver, selection, preparation of petite juries. And this is what I was going to talk about earlier. This is kind of right before this, um, before you actually get arraigned, or excuse me, go to pretrial conference. Um, I'm getting a little bit distracted here. When you go to circuit court, you have a certain gap or window of where you can, prior to that, if it's not a felony case, misdemeanor, like we just covered, you can get a less than 12 jurors. All right. That's going at the same time that you're doing all these pretrial conferences. So again, you have to do the jury thing before you get into circuit court. It's got to come from there. You have to get it done in district. Once you get in, then you can start messing with, as the code is rules of procedure are dictating here. But the whole time, this is where you're having all of your time taken up. Pretrial, all right, all the pretrial stuff where you got to get prepared, have your, um, uh, get your subpoenas, get all of your. If you have a deposition, which is very rare, has to be approved. All of that stuff starts getting done. Okay, so let's see if I can't get this over here. Let me go back up. All right, so we had the scheduling order. I think I covered that. Purpose is to set boundaries, deadlines for discovery, pretrial motions. Just keep it. They want to keep it on track because judges, believe it or not, they have a time clock on them that comes from above them. So they're going to push you. It's inevitable. Like I said before, if you haven't done your speedy trial, if you haven't picked out what kind of jury you're going to have, you're done. Um, it's waived. The jury trial is not waived, but your right to do less than 12 would be waived. After this, it would come down to pretrial conferences, and we've covered that, suppression issues, stuff like that. You may even have where you're wanting to exclude potential witnesses. Um, that's more rare. But definitely stuff they may testify to, like evidence wise, where you would want to suppress it. This is where this all takes place. And you start doing motions to dismiss. You'll start doing those as well at this point with the pretrial conferences. You may get one or two scheduled. You may not get discovery. You may have to start doing motions to compel. This is all going to delay your trial. All right. From here, like I said, we get officers plead guilty, start coming in, but unless you're a first time offender, you're probably going to go to prison. It's pretty good. It's a pretty good bet that's going to happen. We'll skip on. The last of the pretrial conferences. That's where you're going to have this done. All of your mental health examinations. You have to. It sucks in Alabama. I mean, you can get an independent one, but you have to go through stupid. God, I can't think of the name of the hospital. It's it's really not a hospital. It's a prison hospital. Um, when you start getting competency stuff done, you got to go through them, which is the state. They find everybody's competent. Everybody competent. You could have a drooling, knuckle dragging defendant that can't speak or doesn't matter. Guarantee you, I've had them where they literally are crazy, talking to the ceiling. Legitimate, legitimate schizophrenics that they just can't help in their defense. They just can't. Oh, oh, they're good. So that's when you have to go and get your own done. And if it's a appointed case with the like a state case where they can't afford a lawyer, and you got to get permission from the court to get it paid for. I mean, it's just a pain in the ass. It's a pain in the ass. So just know you're probably, yeah, you're going to get your mental health examination, et cetera. And if, God forbid, if you enter a plea of not guilty by reason of insanity, you've already done that at this point. You're never going to win that case. Nobody wins those. The standard for insanity defense is just too high. And it really shouldn't. It shouldn't be. It really shouldn't. There are a lot of cases where the person is they're just off. They're crazy. They don't understand or appreciate what they've done, or that it was wrong at the time. Um, and they need to really, instead of a prison, they need to do time in a mental hospital. And unfortunately, starting with President Kennedy and into Reagan, um, they just started drying them funds up for those. And so most states, unless the state runs a facility, you're just not gonna have access to that. It sucks. It sucks. All right. So Rule 15 covers preparation for the trial, pleadings and motions. It dictates what kinds you're doing. Rule 17 is your discovery protocol and what you're going to go through for discovery. Rule 17 governs subpoenas. As I said before, you cannot just issue a subpoena. Not in Alabama. You got to get the court's permission, etc. All right. So this trial by jury, we've already read all of 18.1. So let's go to 18.2. Jury info. Now, when you come in for a jury trial, you're already past all of the last spots to jump off. You have set the trial on the docket. You're like on March the 3rd, a Monday, we're going to start voir dire with the jury. We're going to pick them and strike the jury. And they're called a venire. So the jury information, juror list, you do get a list. It's just their names. Different counties and places are a little different. It's very limited. I know like Kentucky will give you kind of a background, almost each one as they filled out a questionnaire and stuff, but it's real limited in Alabama. And then sometimes, I mean, I've seen it where it's just the person's name, just to make sure you don't know them, or the state doesn't know them, or there's a conflict of some sort. Prior to voir dire, each party upon request shall be furnished with a list of names and addresses, other prospective jurors called for the venire, together with such biographical info as to each prospective jury. Usually it's like it'll be like, their name and birth date and very basic stuff, very basic, but that's where you get into striking for cause and bats and challenges for your jury. Jury questionnaire. If a juror questionnaire containing personal info is obtained from a prospective juror in any case appealed to the Court of Criminal Appeals, the questionnaire shall not be included in the clerk's portion of the record. They don't want to know about that. They don't want any of that shit. They just want the call. They just want the law. They want the case. You better have some law. That's it. That's all they care about. I mean, unless you do have a jury tampering, but again, um, the questionnaires are not going to go any. I've never heard of it coming up where they've gone, even on a tampering issue. 18.3. We're still in the jury trial stuff. This next to the actual procedure for like evidence, etc. This is where most of the rules apply. Because it's striking a jury, it has to be done right. Okay. Challenge to the trial veneer. Any party may challenge the veneer on the ground that its selection is there. Its selection in its selection there has been a material prejudicial departure from requirements of law. Challenges to the veneer shall be made by motion in writing or on the record. This is where you start getting into Batson challenges. I'm not going to go into Batson. You can look it up. It's Batson v. Kentucky. Basically, that jury, they said he was unduly prejudiced because they purposely struck all black people from the jury. It was a black defendant. So that's kind of what that one's made for, but it's also being stretched and used in other ways. So if you hear a Batson challenge, that's what they're talking about. Usually your challenges will come with, in pretrial, it's going to be either um, you're trying to suppress evidence, or maybe get a subpoena, etc. And then your next challenge would be then a Batson challenge, especially on an appeal. If let's say, I don't know, let's just say you have a, um, I'm trying to think of a good race point of view. Well, let's just go the typical. You got a black defendant, and the jury and the state strikes every time they get a chance. They strike them, a black person, every one of them. That would be what you would bring up on appeal for Batson. You would actually do a Batson challenge during the trial, or during question, or uh, for the uh, juror striking a jury. That's when you would do it. All right. 18.3, challenge of the trial of an honor. I think I just did that one. Yeah, that's when you would make the challenges. You can, like I said, you can do it too once. It's not a good idea. I mean, obviously, if you're challenging, you got to bring up. Remember, anytime you do an appeal, you can't just appeal stuff and say, "Oh, well, I was wronged." You've got to have it on a record. So anytime the attorney, objection is, lacks foundation and blah 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 blah, whatever. Um, it's irrelevant. It's hearsay within hearsay. If you get overruled, you might hear especially if it's happened more than once, you might hear the lawyer say, "Judge, I just want it for purposes of appeal. I want it to be an ongoing objection," and they'll notate it. That's it. That preserves your appellate material. Okay. The Batson stuff, you better have freaking raised, or you're probably going to get it. You're probably going to get it as deemed. It's waived. It's done. Um, yeah, motions of the challenge the venire shall be made before trial and shall be decided prior to voir dire. So the voir dire is where you really start to get into the jury itself. Maybe you have a I don't know, pot case or whatever, and you may ask, does anybody here have a problem with marijuana? Period. End of story. Like, just it's illegal. Should never use it. Whatever. And you may get a few hands, and those you would strike for cause. Okay, you want them gone. You don't want to keep them. It's a game. It's a game. That's it. Picking a jury is a game. Um, if you don't, you know, with the YSL trial, from what I've gathered from it, it wasn't a slam dunk going in. I think there was a couple that was saying guilty. It was over time when they went through it. So they picked a good jury. Um, you just never know, man. I mean, jurors can tell you whatever. Um, they may say, "Oh no, man, smoking weed's fine. It's totally cool." and then you find out that that's not how they feel, and they've convicted your client. It sucks because you really are relying on 'em. That's why some guys, they will say, "I want a bench trial. I trust the judge over a jury." There are people that are like that. Usually they're convicts, though. I mean, that's just it, because they know that the system itself wants to settle the case out. All right. From here, we go over to Rule 18.4, selecting the jury. I may call it on this one and just make this a shorter video because this one's going to get pretty deep. Um, and once we get this done, the basic overview of criminal trial procedure, I'm going to go back and do rules of evidence, which is can be, I don't know, it just depends. It's not a material that you can make it exciting. It's just not. So I may do one video on it. If it doesn't do well, then I probably won't do it anymore. I just don't ever see anyone that does it. Um, they just, like I said, it's not sexy material at all, at all. Oh shoot! There I go. Come on, come back. No, damn it! I've lost my tabs. What the hell happened? Here we go. I was about to get really mad. This would have been the fourth time to redo this. Damn it! All right, the procedure for selecting a jury. This is where we get into the nuts and bolts of it. Procedure for selecting a jury. Compilation of a strike list. Calling of the case. Upon the trial by jury of any person charged with a crime, the court shall require a strike list or list to be compiled from the names appearing on the master strike list as established in Alabama Code 9075, 121674, or alternatively as provided in 1216, 145, and 146, and compiling the strike list or lists. Names of qualified jurors may be omitted on a non-discriminatory basis. Um, a strike uh, a strike list shall be compiled for the trial of any case at hand, and a copy of that strike list given to each party. Okay, it'll be usually juror numbers at that point. Juror 106, because they come in these big binaries, big pool of maybe 50 or 100 people that show up for jury trial duty. Um, that, that's how that works. All right. Um, the prospective jurors whose names appear on the strike list shall be brought into open court, and the case shall be called. All right. Oath of prospective jurors. It's a freaking oath. That's where they charge the jury. All right, that's it. Um, I don't want to go on through reading all that crap. Following the administration of the oath, the court shall initiate the examination of prospective jurors. Those whose names appear on the strike list compiled. The strike list is, and both sides get them. They're the ones that get recycled, sent back for whatever reason. Compiled pursuant to Section A by identifying the parties and the counsel, briefly outlining the nature of the case and explaining the purpose of the examination. The court shall ask any question thinks necessary touching the prospective juror's qualification to serve in the case on trial. Okay. Next, voir dire, depends on that. Doesn't matter. Same thing. Voir dire. The court shall permit the parties or their attorneys to conduct a reasonable examination of prospective jurors. This is the procedure, and I know many of you saw it in the YSL trial where they're. I think they covered that. I picked it up later and later in through the case to start watching, so the jury had already been picked, but you should have it in there. You should be able to go back and look, and you can see how they struck the jury. Um, Following the administration of the oath, the court shall initiate examination. The court shall ask any question it thinks necessary to touch on the. I just read that. Where is it at? Stop it. Okay. Voir dire. The court shall permit the parties or their attorneys to conduct a reasonable examination of jurors. Court may also conduct an examination of jurors, and the court, in its discretion, may direct the examination of one or more prospective juries be separate and apart from the others. Do it in the same room. Yeah, by this point, you're probably down to 14, somewhere in there. Um, you should be about ready to go with your jury. Um, after voir excuse me, you should be down with your. Usually, it's two alternates. You never know who will, you know, die on you or get sick or whatever. So you got to have somebody to relieve them. All right, scope of exam. Voir dire examination of prospective jurors shall be limited to inquiries directed to basis for challenge for cause. Okay, cause. Remember that because Batson deals with it. For cause or for obtaining information enabling the parties to knowledgeably exercise their strikes. Cannot be on the basis of something like a protected class race. Can't be. All right. And that's what Batson kind of set that ground. Well, it did. It set that groundwork as to what the courts will use. Okay. Scope of exam. Voir dire examination of prospective jurors shall be limited to inquiries directed to basis for challenge or cause. I just read that again. Challenging for cause. When a prospective juror is subject to challenge for cause, or it reasonably appears that the prospective juror cannot or will not render a fair and impartial verdict, such as, how do you feel about the death penalty? Kill them, every one of them, hang them, whatever. You don't want that person on the jury. That's a hell no. They got to go because you're just not going to get a good verdict out of them. They're too biased. The court, on its own initiative or on motion of any party, shall excuse that juror. Challenges for cause may be made before the parties begin striking the jury. You always will do that. You will always strike them for cause. The rest will be um, just to whittle them down. Okay, that's all you'll be at once you get done with the strikes, or I call them Batson challenges and strikes for you get through the Batson portion. Um, you're pretty much down to the last um, questions that you could come up with. And trying to read the jury. You'll. I've always been fairly decent at reading people, reading juries. It's look, it's not an art. Well, it is an art. It's not a science though in any means, but there's an art to it. If you're good at reading people, you might be able to see how people's body language. They may be lying their ass off to you. Can't prove it, but their body language may give them up. So it just depends on the attorney. Some attorneys suck at picking a jury. They hate it because they suck. They don't pick good. The discretion of the court, it can be made out of hearing of the prospective jurors, but shall be on the record. All right, now we're on to striking of the jury. All right, we're done with the cause. We're on to striking the jury. I think I'm gonna leave it at. I think I'm gonna cover Rule 18, and then we're gonna come back for the rest of it. Third part. It's getting too long. This is it, though. This is what happens in a jury trial. I mean, this is how you get through the case. We've covered the challenge for cause, striking the jury in general. After voir dire examination, the prospective jurors have been completed and challenges for cause have been exercised. The court shall cause to be compiled a list of names of prospective jurors who are competent to try the defendant. It'll be the final list, and from which the jury shall be obtained. If in compiling a list of names of qualified juries are omitted, the accessory omissions shall be made on a non-discriminatory basis. The parties consent to the use of lesser number basis. Unless the parties consent to the use of a lesser number, the names will the number of names appearing on the list shall not be less than 36 total if the offense charge is punishable by death. So that's what you start with. That's your venire. Okay, that's a whole pile. All right, you may have a couple people show up or 100 people show up, but just for your case, if it's a death sentence case, then you're going to start with 36. 24 if it's a felony not punishable by death, or 18 if the offense charged is a misdemeanor. Remember, we're back to that backdoor way of getting an appeal, getting a jury trial on a misdemeanor charge. District attorney shall strike first and shall strike from the list the name of one. Let me see if I can't make this bigger. This is driving me nuts. And I can't make the. Come on. Sorry. It just takes a while to get this thing. Ugh, it takes forever to get this thing to work sometimes. All right. Shall strike from the list the name of one juror. The defendant shall strike the next one juror. You continue that process to strike off names alternately. Damn, what's wrong with me tonight? Until only 12 remain. Like I said, you have two, um, um, two reserve. You got to have them. It's a bad idea not to. Very bad idea. In the event the list of competent prospective jurors is reduced to fewer than the number required by the subsection, the court shall add prospective jurors in a manner prescribed in subsection H. All right. If you've got two or more defendants and they're being tried jointly, to the minimum number of names otherwise required for striking, there should be added. Basically, it's just going to add it. All right. You're just going to double it. Um, I, most people don't ever do multiple defendant trials. It's too much bullshit. It's too complicated. Just like a YSL trial. They could have cut that damn trial into slivers and gotten probably convictions on it, but they chose not to. You know, RICO is usually a sure way to lose. It's not a good idea. All right. Um, let's see. Upon refusal of the defendant to strike, if any defendant should fail to or refuse to exercise a strike which is entitled, then the judge presiding, you got to get them dwindled. You got to get them whittled down. So you don't get to just not do it. You've got to do it. The judge shall then exercise the strike for him or her. Alternates. Court may deem in its discretion qualify such jurors as deems necessary, except in a capital case. So, like I said, it's usually two. You usually end up with 14. And then once the case is done and goes to the jury, then they're excused. They can still be called back, if they're in the middle of jury deliberations and somebody died, they're going to call them back. Okay. Uh, covered the alternate numbers. And the alternate jurors do not get to deliberate with the jury. Okay. So they literally are done at the end of the trial. When the case goes to the jury, they get excused, provided they don't get dragged back in for any other reason. That's it. They're done. They're out. They go home. Procedure for selecting. When alternate jurors are being used, the parties shall strike from the list according to the procedure provided in subsection F1. It's the same procedure until there remain 12 names on the list. The last person or person struck shall be the alternate or alternates. If it becomes necessary for an alternate to replace the principal juror, then the last person struck shall be designated. The identity of alternate jurors shall not be divulged to the jurors until the jury retires for deliberation. All right. So they're separate. All right. We really try to make everything as fair as we possibly can to where the jury is not deliberating until they get the case. That's when they learn each other. I think it's an old Fonda movie, 12 Angry Men or something like that. Um, it's a good one to watch, see how the jury operates because they don't know each other. They don't have a clue. They don't even know each other's names because they're not allowed to do that. So once they get the case, then they become a cohesive group. Insufficient number of jurors. I've never seen it. I've never seen it. Whenever there's not enough qualified jurors in attendance to form the juries required, the judge presiding shall draw from the trial court list compiled pursuant to the provisions of the statute, the names of as many prospective jurors necessary to impanel all of the juries than required. I have never seen that ever. So I'm not saying it can't happen, but I, I've never seen it. And striking juries, if prior to the commencement of striking, because of challenges for cause or any other reasons, the number of names on the list from which the parties are to strike is reduced to fewer names than the minimum established subsection F, then unless the parties consent to the use of a lesser number, then the court shall fill a deficiency from a list. Um, Basically, just building it back up. That's all they're doing. Got to have a you got to meet the statute. You got to meet the rules of procedure in any statutes that govern jury trials. Sure, I think I need to go back up. Yeah, we're in Rule 19. We're getting into trial. Yeah, that's Rule 19 as well. This is 20. All right, I'm just going over. I think I'm gonna stop at 18 because picking the jury alone, this is already look. This isn't sexy stuff. This is boring. This is what law school's like. I mean, it's mind-numbingly boring. But you got to know it. You got to know it. You got to be able to do it. You've got to be able to pick your jury. You've got to be able to know how to the jury system works. But this is not sexy stuff in any way for criminal procedure, and really not much of it is. Yeah, judgment. Yeah, we don't need to worry about judgment of acquittal yet. That's a little ways down the road. I think that's where I'm going to leave it. I've already covered 18.3. Yeah, this is hard to do, especially for this. Um, I'll cover. I don't know if I covered 18.3. Challenge to the trial of veneer. See, I end up doing it. Veneer, venire. Any party may challenge the veneer on the ground that its selection has been a material prejudicial department from the requirements of the law. Challenges shall be in motion. Yeah, I've already covered that one. That's your Batson. That's your Batson stuff. Okay. So the next step will be Rule 19, which will be trial, and then we'll go from there. Let's see, we might be able to cover it in one video. I think so. Then we'll go from there to Rule 20, which is motion for judgment of acquittal. That comes after the close of evidence. The jury doesn't have anything to do with that, but it's in between the jury going out and the close of evidence. Right? Just keep that in mind. And I think that's about where we need to stop. Yeah. This is a lot. I mean, dude, it's a lot of it's a lot to gather. It's a lot for an attorney to tell their client. I mean, because I'm being honest, most attorneys are not going to go into this. I have gone in way more depth than I'd say over 80% of attorneys are going to do. They're going to give you an overview, 30,000-foot overview. Um, as stuff comes up, then they'll start giving you like, hey, we're doing this because of X, or we got to do this because of Y. But as far as like actually going into this kind of detail, it just doesn't. You don't have time. Um, I mean, it's unfortunate, but it's a fact. You don't have time. You will not get through. You just not. Um, so for next time, we'll start with Rule 19, the trial, how trial order proceeds. Um, you are literally at trial. This is day one. The jury. That's your first day. That is your first day. Is you're striking and picking a jury. Once you get that done, then you go in. We go into actual trial itself, and then other sets of procedure kick in that will govern how the trial goes forward. Like you don't just get to go in any order. Um, there's set rules to it. Then Let's see here. Yeah, that's where we'll end up there. I think that's a good idea because I do not want y'all to get mind-numbingly bored. I think we've already done like 40 minutes of this, which is freaking way too long. Way longer than I ever wanted it to be. Trust me, this sucks. This is not cool when I go over. Because I don't want y'all to get bored and then say, "Man, I'm so tired of this," and then not learn it. Um, the whole point of this is to get y'all to be able to learn how the system works. And so that's why I'm going to split it up. Um, let's see. Yeah, we're good. Yep. Okay. We'll get into verdicts next too in the next video. Cool, man. All right, guys. Thanks for joining. Sorry, this did not turn out the way I was hoping it would. I was really hoping for it to be a lot more interesting than this. It's just not. It's just really boring. I think the rules of evidence get to be more because then I can start giving more analogies and examples of stuff that's happened to me or someone else that I know, and um, why does evidence have to be done the way it is? Why does it have to be presented the way it does? Why can't you have hearsay? That stuff, it's not sexy. Nothing in the law is sexy. Okay, it's freaking boring. 99% of this shit will bore you to tears. And I sure any day you go to a law school and just peek in the window of one of the classes, you'll see it. It's just mind-numbingly um, uh, specific stuff that is just it's just not interesting. But I always liked contract law. That was my thing, and equity. Um, things like collateral estoppel, latches. These are all equitable remedies. And if somebody asked for it, I wouldn't mind doing a video on contracts and how you can keep your ass out of hot water with a contract. All right, that's gonna be it for now. Uh, thanks, everybody. Just if you wouldn't mind, please subscribe, uh, leave a comment, hit like, just something for the algorithm, please, if you wouldn't mind. Thank you so much. All righty, I think that's gonna do it. Until next time. Bye bye.